Welcome to Ground Rules, Employment Law Over Your Coffee Break. My name's Pam Howland, and I'm here today with Doug Plass and Jennifer Walrath. And we're talking about LGBTQ protections under the law and the current state of what that law looks like, and some confusing areas where it looks like the law has changed, but hasn't really changed. So what we thought would be fun and interesting and perhaps helpful to you all is identifying some of those issues and conflicts and possible changes so they're on your radar as we move into late 2025 and early 2026. We think there could be some changes and developments coming, and we certainly have seen a number of things in 2025 that have definitely signaled a shift in administrative view of this area of the law anyway. So I think I'm going to turn it over to Jennifer, because Jennifer has done quite a bit of research and studying and monitoring, and has some pretty good content put together. So Jennifer, out of all of us, I would say is best to kind of kick this thing off. So I'm going to turn it over to Jennifer to kind of lead us in this discussion about the current state of LGBTQ plus protections.
Well, thanks, Pam. Always so complimentary. Well, I think where it makes sense to start is, what is the law currently? And although it may not seem that way sometimes, I would say the law of the land still right now is the case of Bostock v. Clayton County, which the U.S. Supreme Court decided in 2020. And in that case, the Supreme Court said that the definition of sex, so it's one of the protected categories under Title VII, right, is that you can't discriminate against someone based on their sex, that includes taking adverse action against somebody because of their gender identity or their sexual orientation. And, there is language in that case that suggests that wasn't limited to simply firing someone, right? That it could be taking any discriminatory action, potentially up to and including, right, harassing someone, for example, based on their gender identity or sexual orientation. The only thing that decision very clearly said we are not deciding today had to do with things like bathroom use and locker room use. But beyond that, the language of the decision really is relatively broad, saying things like discrimination based on homosexuality or transgender status necessarily entails discrimination based on sex. So, reading that Bostock case, I would say, generally speaking, that decision said that you cannot discriminate against someone based on their gender identity or sexual orientation. Now, so as well, since that case was decided and prior to this administration, there were a number of lower court decisions, district courts, courts of appeals, applying that standard and applying it to circumstances that, we here would consider like your typical Title VII type claims, right? Someone says they were, demoted or not promoted because of their gender identity, or that they were being harassed in the workplace and subjected to a hostile work environment based on their gender identity. And we saw those kinds of cases being decided, and employees bringing claims on that basis, having claims to pursue. So that really, I think, still is the state of the law, in the sense that if you are an employee who fits within that protected class category on those grounds based on sexual orientation or gender identity, there is a legal claim still under the law. Now, I think what we'll end up turning to now is there definitely have been signals, right, from the current administration that it feels differently about that law, and is taking steps to kind of chip away at that standard and at that law, and seeing if it can make some changes. So I don't know if Doug or Pam have anything to add kind of on, kind of the legal piece of it, right? Because the way I read things, at least, the claims are still there. It's possible to bring them. I don't know what courts would do with a new claim today, but certainly the claim's available as I read the law currently.
Yeah, and I'm glad you kicked it off with that, because I think that is an area that's maybe causing some confusion for employers, because we've since 2025 really rolled around a lot of conflicting things that we're going to touch on, but the law is still the law. That Supreme Court case is still in place. Nothing has touched that. It hasn't been reversed or overruled. And I think, if you have supervisors or others who aren't really looking at the big picture, they could look at some of these things they've seen on the news in 2025 and think that the law has changed. But really, the law itself is pretty much intact. It still looks like it did in 2024.
Yeah. And so maybe turning a bit to, what have maybe employers been seeing in the news and been hearing about. And I would say, several things have happened, right? I mean, there have been various executive orders that kind of came out almost day one. I mean, maybe not literally, but within the first, say, week of the new administration, maybe a few weeks. Making very clear that the administration views this idea of sex as it's protected under Title VII as being a very binary concept based on biology, right? So not recognizing the concept of gender identity. And I would say gender identity in particular is the topic that's seeing the most pushback here, right? So for example, people who are transgender, right? A concrete example of someone who may say, I have protections based on my gender identity. The administration has issued executive orders saying, no, sex is a binary concept, man, woman, based on your biology. And kind of on the heels of that, we have seen the EEOC, the federal agency charged with enforcing Title VII, make changes to how it approaches these kinds of claims. So, for example, the EEOC typically, if an employee filed a claim for, say, harassment based on gender identity with the EEOC, it would look at that claim, maybe investigate it, do some sort of process to look into it, maybe help try to resolve it, amicably between the employee and the employer. And ultimately, if there was no resolution, make a determination, right? Is there probable cause or not? And then issue a right to sue letter. And that whole process takes, maybe a year or so, maybe more. But now what the EEOC has said is we basically don't recognize those claims. We don't think that they should be permissible or allowable. So when they come in the door, what they're doing instead, as far as we understand it, I mean, we don't work for the EEOC, but what comes out in the news is that what's happening is that they just simply issue the right to sue letter to the employee immediately, because that's a statutory requirement to say you can now go to court. So what that effectively means is that if the employee, they can file the claim and they'll get their right to go to court, but they're not going to get that administrative process to perhaps work through it a little more amicably, sooner, more easily, and they will not have any determination by the EEOC as to the, strength or weakness of their case. So that's kind of one thing that's happening there. The other thing that has perhaps been out and about and that you may have heard of is that, in 2024, so last year, the EEOC issued updated anti-harassment guidance. And it was really remarkable for us because it was the first time in like 30 years that the EEOC had updated that kind of guidance. So it was very welcome. And as usual, there were a lot of like good examples in there, concrete guidance that's really helpful for us and for employers, right, when they're navigating these issues. And in that guidance, the EEOC very clearly took the position at the time that, say, harassment based on gender identity violates Title VII, and there's examples in there of situations where maybe customers or coworkers were harassing a transgender employee and saying that is harassment that violates Title VII. Well, more recently now in 2025, there was a lawsuit in Texas, and a federal court in Texas invalidated those portions of the guidance. And the EEOC essentially was not enforcing it anyway at the time. So now that guidance, that piece of the guidance, right, relating to gender identity and sexual orientation is gone. And so that's all a very long way of saying there definitely is a very clear signal from the current administration that it disagrees, essentially, with the Bostock decision, either to some degree or completely. And so it has done what it can, I would say, to take that position and not enforce those kinds of claims. And we will see what happens. But you may well have heard about that. I would say it doesn't change the law right now yet. But it's definitely something that I think can make it more challenging for employers to know, like Pam was saying, what is the law? What are we expected to do? What can our employees do or not do in the workplace? You may even have employees who feel emboldened to behave in ways that they maybe wouldn't have before, for example. So I think it has created a lot of confusion.
Yeah. I mean, it's confusing me because this whole idea, because what the administration's saying is, okay, we have two binary sexes, right? And, but that's what Title VII says as well, right? So this idea that, whether it's gender identity or whether it's like some of the earlier cases said, before Bostock, really non-conforming with sex-based stereotypes, really comes down to, like, if you know what Bostock said is, if you know the sex, if you need to know the sex of the individual in order to kind of understand what happened here, then that's an issue. Title VII is implicated. Whether or not someone is saying, this is my gender identity, if someone is not conforming to some sex-based stereotypes, they're wearing the wrong clothing, they're not doing things, they're not using a name, kind of seems to me that whatever their identity is, it's still based on sex, based on Bostock and all these cases that came before Bostock. So I guess, and we talked about this a lot in the spring, I guess these executive orders and kind of this guidance from the administration, it's really not going to change anything unless the courts actually change the law. So I don't know. I get confused when I start thinking about this stuff and start spinning in circles a little bit. So anyway, that's just kind of my perspective.
Yeah, we have, I guess taken a couple steps back. We had these executive orders that came out in the January, February timeframe. And if you really think about what those are, I mean, they don't change the law. They can't change the law. And what they really are is a directive from the administration for a federal agency interpreting a statute to move it in a certain direction. And that is what we've seen here, right? I mean, for those of you who've been watching what's gone on with the EEOC and how that looks very different, if you get the EEOC emails, for example, and you can see the EEOC communications and priorities, they do look very different than anything we've ever seen coming from the EEOC, in the sense that they do seem to be walking back some of the protections that a year ago they were advocating for. So we've seen the executive orders, we've seen the EEOC take them and then try to convey to the public that they are following them and moving the law in a certain direction. Kind of an interesting thing is that the EEOC needs to have a quorum in place to take a lot of action. So they need to have a certain number of people help me out, guys, like on their board or like on there as commissioners. Yeah, before they can take action. And up until recently, they did not have enough to really do a whole lot. But now they have obtained quorum. So it is possible that we could see some more significant changes of some type, maybe in terms of different EEOC guidance that maybe clarifies the EEOC's position on some of these things.
Yeah, I was just kind of thinking about what Doug was saying. You know, I think why this is so confusing is that in some ways we have this, you know, because Doug is right that the law, there are some very applicable cases even before Bostock, right? This idea essentially that if you're just treating someone badly in some fashion, whether that's firing them or harassing them because they don't conform to a gender stereotype, sexual stereotype, that has for a long time been considered a violation of Title VII. But it's like now all of this is being put into, I think, a more modern political box, right? And it's being talked about in more modern terminology, and in ways that sort of are the messaging, right, of the current politics, the various parties, right, and their views on these things. And so in some ways, for the public and for employers who are consuming this news and information, it is being talked about in a way that perhaps is not truly the law, right? Which I think is what kind of makes it hard to actually know what are the rules that apply to me, especially when right now what the EEOC has been doing has been more sort of, you know, press releases, messaging and things like that. That could change, right? So this definitely is an area you want to keep an eye on. But I guess the high level, the main take home for employers, one of them is whenever you have to confront this issue in your workplace, right? Where you maybe have employees who have ideas about this subject that, or perspectives that are in direct conflict and they're having trouble, right, getting along, for example. How you handle that may well depend on what the current state of the law is, not just what has been said in the news about these things. And you're probably going to have to dig pretty deep to actually understand that and not just go based on what the EEOC is saying. It may have some relevance or, you know, to the analysis, but you're probably going to have to go deeper than that even to really know what is the law say.
Yeah, I agree. I mean, I just think that if you bring a claim and you say, you know, this claim is based on my gender identity, you could just restate it and say, this is based on my sex for not conforming with sex-based stereotypes, and really have all the same facts. So I feel like it's all a lot about messaging and not really about what the law is. And I think that's something we want to hit home, you know, until the Supreme Court tells us otherwise. Bostock rules, and we need to kind of pay attention to that.
But to Pam's point, now that they have a quorum, you know, certainly the EEOC now has, once the government reopens, right now if you go to the website, it says the EEOC is closed, so nothing really is happening presently. But once the government reopens, we now have a quorum again with the commissioners. They have the authority and ability now to do things like repeal guidance, issue new guidance. And again, guidance isn't the law necessarily. It is helpful for those of us trying to comply with the law, and it can influence how courts look at the law. But also the EEOC could even do rulemakings, right? And actually issue some kind of regulations that, you know, could apply in this space. And, you know, those are the kinds of things that have a little more heft to them, I guess, right? It's a little more significant. It's beyond just an agency saying, here's how we view the law. So we'll see, right? It's possible things could happen, or court cases get teed up where courts do take a view that sort of puts Bostock at issue. Now, I want to be clear, that hasn't happened yet, right? It hasn't happened yet, but it could. So this definitely is an area that you need to keep an eye out and see what developments happen.
Yeah, and thinking about what that means for employers, right? You know, like, again, Bostock's still the law. EEOC, if your complaint ends up in front of the EEOC, which again, if you're here in Idaho, it may or may not, you're probably going to land in front of the Idaho Human Rights Commission instead of the EEOC. But if it lands in front of the EEOC, and if the EEOC doesn't take it, that just means the employee is going to be able to file a lawsuit quicker, right? It's not like they're terminating those complaints. They're just giving the employee a right to sue letter, which basically means they can go straight to court now. So that's one issue. It's certainly not like these claims are being deemed to be not valid. Instead, employees are going to be able to get an answer on it possibly a little quicker. And I would just note, too, that about a month ago, I was having a conversation with Ben Earwicker, the director of our Idaho Human Rights Commission. And Ben, if you're out there, please correct me if I'm wrong. But I did not get the impression that at the local Human Rights Commission, I did not get the impression they're turning these complaints away or immediately issuing a right to sue letter. I think on a local level, they are still prosecuting them to some extent, or at least investigating them might be a better way to word it. So these complaints still could go forward, and the law is still in place at the United States Supreme Court level. So.
Yeah, and I think the only other kind of thing I wanted to throw out there, which I think a lot of employers are aware of, is there's another category of protection under Title VII that can complicate matters in some situations, and that's religion, right? If you have employees, let me back up a second, right? So under Title VII, there are protections. You can't discriminate against someone based on their religious beliefs. And religion also is a bit unique out of Title VII because there is an obligation to accommodate an employee's sincerely held religious beliefs. And in some instances, and not just in this context, but also in this context potentially, you may have employees who have religious beliefs that are in conflict, right, with the protections of sex under Title VII as, laid out in Bostock in the cases that came before it. So what do you do, right? If you have an employee who says, for example, I refuse to recognize anything about my transgender coworker because my religious beliefs don't allow me to do so. And transgendered coworker says, I am being harassed by this other employee, right? I mean, if you're the employee, you have potentially two competing claims, right? And the question kind of can come up of, do I need to potentially violate Title VII to protect the employee who claims they're being harassed? Violate that protection in order to accommodate the other coworker's religious beliefs? That essentially that's okay, right? Because my religion says that person doesn't exist and I don't have to acknowledge. I'm being a little bit overstating, but it is complicated. But essentially what the law says, at least in the Ninth Circuit, is that if an employer is facing potentially having liability under Title VII, so in my little scenario, right, that I have an employee who might sue for harassment under Title VII, I do not have to accommodate because it's not reasonable. But I will, and just so you know, for public employers, that's not a per se rule. It's only meaning it. That standard really only exists for private employers. This protection that says, look, you don't have to violate Title VII in order to accommodate someone's religious beliefs. For public employers, it's a little bit less protection in that sense. It may be the case that that's how you handle it, but not necessarily. But all to say, it's actually a very complicated area, but basically if you're an employer who is facing two competing claims like that, it in almost all circumstances is going to come down to the facts, the situation at hand, right? is there really a risk of violating Title VII? What is that risk? How big of a risk is it? What is the person's sincerely held belief, and how does it conflict with your policies and the expectations of the law? Things like that, right? And it is hard. It's very complicated, right? You're going to have two employees who feel very strongly that their rights are potentially not being protected. And how do you navigate that, right? Maybe even more than two employees. But I think for employers, it's difficult. It's hard to know what would happen with that. And at the end of the day, you may end up in a situation as an employer where you have done your level best to comply with the law and be fair to both employees, and you may end up still with a claim from both employees. I think where some employers are sitting today with these kinds of issues. And I will say, too, for what it's worth, talking about the EEOC, one of their priorities certainly has been, I think, enhanced focus on religious protections. So that also just sort of puts a lot more of this, I would say, front and center in a way that maybe it hasn't been as much historically.
Yeah, we know there was a shift in the law several years ago when it comes to religious discrimination claims and religious accommodation claims, making it somewhat easier for an employee to qualify for an accommodation based on a sincerely held religious belief. So Jennifer's point is a good one. I mean, that adds another layer of complexity here. The big takeaway for employers, I would say, take any claim of religious accommodation, a need for an accommodation, or religious discrimination seriously. Investigate it. Make sure your supervisors know that anyone coming to them with an accommodation or a claim of discrimination or harassment needs immediate attention. And then that you could have a scenario with LGBTQ protections at issue, religious discrimination at issue. Those are going to be tricky situations. 100% call for help, get legal counsel. And I think, again, the big takeaway, make sure your supervisors know enough to know to flag these issues and get help if something like that comes up. What you don't want is someone asking for an accommodation and a supervisor saying, oh, we don't do that, or someone, LGBTQ, an issue comes up and a supervisor says, no, we don't have to do that. That's like your worst case scenario, because that looks like a claim right there. So training, staying on top of the law, and really paying attention, because even as 2025 comes to a close, we could see more guidance on these issues. Like Jennifer said, we could see some kind of updated EEOC guidance or rulemaking or something, related to these issues. We just don't know, but there's certainly no reason to think that all the changes that are going to be made have already been made. This is like really early on in the administration, and it's been a very active year for change so far.
Yeah, and I was kind of before this trying to think about, and even over the last few months, like, if you're an employer, it's kind of grim news, right? That we don't have an easy answer, and these situations are going to be tough to work through. I agree with Pam. Certainly the first step is to recognize them, flag them, escalate them to be addressed, right? Just don't ignore them. But what else can maybe employers do? And I have to say, the best thing I've at least come across is respectful workplace training. And again, I don't know for all workplaces that this is going to be the silver bullet that solves all the problems. But in theory, right, even if you have employees who have very differing social, political, religious views, they should still be able to work civilly, respectfully in the workplace. Maybe that's pie in the sky. But I think for at least some workplaces, that could be a helpful tool to, really encourage employees to try, and understand, that, certainly, kind of a do unto others kind of a thing, right? That you want your views and thoughts to be, if not agreed with, respected, and not, derided or made fun of, and your coworkers expect the same. Now, I don't think that's going to solve every problem, but for some employers, I do think that type of training could be very helpful, and maybe even having some sorts of, I don't know, maybe open dialogue's too strong of a term, but, kind of acknowledge that differences exist, and here's some tools to maybe help us to still work together in spite of them.
Yeah, and to really stress that there's the breadth of the law, right? Sometimes I think when you're in this area, a little bit of knowledge is sometimes worse than no knowledge at all. Because if all you are thinking about it in terms of the religious lens, then you're going to make mistakes. And if all you're thinking about in terms of the sex-based lens, you're going to make mistakes. You really need to understand the whole picture, and make sure that your supervisors understand that, they can't just look at the news and say that tells them how to treat a situation. They really need to get some help and training.
Yeah, I like the suggestion for respectful workplace training. Call it what you want. I don't know if it has to have that exact name, but the feedback we are hearing from the HR professionals we work with is unsurprisingly, right? That workplaces are more fragmented than they've ever been because of politics, shifting law, immigration. I mean, just a sense of distrust and division. And I think a lot of people look around their workplace and think, I don't have a lot in common with the people I work with. Is this still a good place for me to work? So whatever you want to call it, some type of venue or forum in order to kind of help bridge that gap so people feel comfortable in their workplace. I think it's a really good time for that. Something for employers to think about. What exactly does that look like when you roll it out? I don't know. I'm kind of like sitting here thinking, I mean, maybe that's a work in progress, but I think for sure giving people the ability to talk about it and find some commonality that makes the workplace better. So that's it for today on Ground Rules. We hope you join us next time. In the meantime, don't forget about our book, our Law for Leaders book. It's the roadmap every leader needs to follow to avoid claims and lawsuits. And then we have a whole host of online recorded training and live training too. So if any of this is resonating with you and you think, oh man, we really need some training for our supervisors on religious accommodations or LGBTQ plus protections, that's the type of stuff that we regularly handle. We love to do that. It's fun for us to get out and meet with people and do some positive preventative work as opposed to litigation on the backside. So again, that's it for today. See you next time.
Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.